Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that we're going to talk about tonight is literally what I left on the cutting room floor from the video that we launched this morning around the Oregon Measure 114, the insanity that the judge put forward. The original video was around 13 to 15 minutes. I went through all the quotes, I dove into the actual decision, and I left a lot of it just to get the breaking news to you. But this video, we're going to dive in to the few of the very specific wording choices and the very specific parts of this decision which make it a prime candidate for the next level of the judicial system, but also how insane this is. Now make sure you hit a like on the... Now make sure you hit the like button, subscribe to the channel, and turn that notification bell on. We are looking to dispense freedom twice daily, and we'd love to have you along for the ride. And with that, let's get to the parts that I left out for you guys. Judge Immergut just did the most amazing mental gymnastics I could ever see on this planet. The Second Amendment doesn't protect LCMs. Oh, large capacity magazines aren't protected? Well, that's of course. And again, wait till I show you. And permitting requirements to own firearms, that's perfectly fine too. But it's not the takings clause because the government isn't taking it from you. It's the police powers that are taking it from you. Literally, this is going to be sent to the next level so fast. It's so riddled with errors and so dumb that you could not make something up that was this much of a reach. But let me continue. I've got a few of the greatest hits here. Legit, this is insane. So now let's go to common use because the judge has some thoughts on common use. I cannot wait to read your comments. Common use alone is insufficient to establish Second Amendment protections. Talking about large capacity magazines. Okay, imagine how many are in the United States. The court finds that while magazines that hold more than 10 rounds of ammunition are owned and possessed by millions of Americans, this fact alone does not automatically entitle these magazines to Second Amendment protection. That is the definition of common use. Let's continue. This court rejects plaintiff's invitation to equate commonly owned with in common use today for self-defense. So what she's saying here is, well, yes, millions upon millions upon millions of people have these, but that doesn't mean they have them for self-defense. That just means they could have them. She's drawing a distinction between the fact that they are owned or if they've been used in self-defense. It is the dumbest comparison you possibly could make. Let's just... Under plaintiff's interpretation, if the firearms industry were able to successfully market a firearm or firearm accessory to 200,000 Americans, which is 0.0006 of the overall U.S. population, then the firearm or firearm accessory would be constitutionally protected, regardless of that firearm or firearms accessory's features or typical use. Plaintiff's argument would make commonality the dispositive inquiry and would erase any consideration of how firearms or firearm accessories are used. The court finds such an interpretation troubling for several reasons. Because you're a gun control hack owned by the left. You literally just said common use for millions upon millions upon millions of Americans does not constitute defensive use because they haven't used it. It's equating the Second Amendment to saying, yes, it's there to prevent tyranny, but since this generation hasn't used it directly in a war, it's not preventing tyranny, so it's not okay. That's what she's equating this to. Let's continue. Let's keep going down this primrose path. Instead, this court finds that based on the credible evidence presented at trial, brandishing an LCM does not facilitate self-defense. Wait for this. Defendant's expert, Jim Urgialis, testified that he could not tell the magazine capacity of a Glock 19, a popular handgun model, when the magazine is inserted into the firearm. So therefore, if the ATF agent can't figure out if it's a large capacity magazine in a handgun or a low capacity magazine in a handgun, therefore you can't just brandish it as defense, so it has no value as self-defense. Literally, she's saying you're wearing a t-shirt that says I have 17 rounds. Well, then it's distinguishable. It's okay for self-defense. But if you don't have a t-shirt on that says that, there's no way for the criminal or the perpetrator to say, oh, he has 17 rounds, so I'm not going to. But if he had 9, I would. She's literally making that argument in a U.S. District Court of Law. We are going down a very dumb path. But let's continue. We've got even more because we're getting into the permitting provisions next. As noted above, the court finds that while LCMs may be possessed by millions of Americans today, they are not commonly used for self-defense. Further, this court finds, based on the evidence in the record, that LCMs have uniquely dangerous propensities. This court finds that, based on the testimony of plaintiff's expert Mark Hainish, that LCMs sold to civilians are often the same LCMs used in the military context. So now it's military weaponry. Okay, well, that's enough of the LCMs. Let's dive into why this is a okay thing for permitting to own a firearm. Own it, not brandish it, not conceal carry it, not carry it on your person. Own it. Okay? Ballot Measure 114's permitting provisions do not violate the Second Amendment. Bruen considered the constitutionality of New York's public carry licensing regime that required an applicant to demonstrate a special need for self-defense before the state would issue a license. In striking down New York's law as violative of the Second Amendment, the Supreme Court noted that respondents, the New York state government, had failed to identify an American tradition justifying the state's proper cause requirement. But the Supreme Court also noted that, quote, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. Accordingly, BM 114's permitting provisions are constitutional under Bruen if they constitute a shall issue licensing regime. So what she just said was, well, according to Bruen, you have to have a shall issue regime. So therefore, if it's no longer a may issue and a shall issue and you're guaranteed to get your permit, well, now you're guaranteed to pay the fines, you're guaranteed to pay the ownership fees, and you're guaranteed to have to pass a test before you eventually get that permit. This is the most egregious measure across the entire United States that they passed a year and a half ago. This is literally... You cannot make a measure worse than this. But this judge's mental gymnastics are making it all okay, even as dumb as they are. But now let me wrap this up and show you how it doesn't violate the Fifth Amendment according to this judge. Ballot Measure 114's LCM restrictions are not unconstitutional taking. Again, I'm going to reinforce this point. The Fifth Amendment provides, in relevant part, quote, nor shall private property be taken for public use without just compensation. There are two kinds of government action which fall within the ambit of the Fifth Amendment: physical takings and regulatory takings. Exercises of police power are not compensatable under the Takings Clause, or compensable under the Takings Clause. This judge just used the Constitution as a freaking floor mat. Let's just go with floor mat. Used it as a napkin to wipe her face from her tyranny as she completely makes mental gymnastics to say all the things that she's wanted to say from her leftist. I'm getting a little spicy. This is an ideologue. This is a person who wants gun control and found a way to make gun control a thing through Oregon Measure 114. This is going to go to the next court so fast that I can't even put a speedometer on it. And then it's going to go right next to the next level. I cannot wait to see this at SCOTUS. All right, guys, and so that right there was everything that I left out from the first video in order to get the news to you quickly. I put it in a kind of a bonus video tonight so you can see all the crazy that they jammed in this, and I hope you guys enjoyed. Let me know what you think in the comments below, and I will see you on the next one. I'm Braden. See you later.